Okay, let me interrupt you for a second. When you say the annuitant has a claim against the bankruptcy estate, what costs do you foresee and again, we understand that this is a situation that would be a worst case scenario, but we have to, when we're dealing with something that's perhaps the person's only asset, we have to think of the potential worst case scenario. So in a worst case scenario, I mean, what costs, what type of additional expense would the annuitant have to go to assert their rights under this?
Well, I don't think it would be great. A number of things could happen. For example, upon the bankruptcy filing by the servicing company, particularly at Chapter 7, the annuity issuer may take that filing, in essence, as a breach in and of itself, and just hold the payments until someone figures out whose rights are which under the particular arrangement. If the trustee rejects the contract or fails to act within 60 days, which means automatic rejection, the annuitant shouldn't be harmed because the trustee is going to make the payments to the annuitant during that 60 days. Okay, any payments that come into the trustee's hands in that 60 days or even after will be held in the registry of the court. So the annuitant's funds are always going to be protected. They're going to be somewhere. The cost to the annuitant should be nominal. It may require the annuitant to retain counsel to protect his or her rights, which would
have a little bit of a cost. Now,
which could have a cost, and that's right.
Right. Now, when you say that could be held, you said potentially being held in the registry of the court. That means that the payments would actually be suspended for perhaps a short period of time.
Yeah, and I should say they'll be held in the trustee's estate account, so for that particular case. So I think it would be a short period of time, because if the trustee rejects the contract or abandons the contract, okay, it's going to happen typically within that 60-day period, and so you're talking about a relatively short period until the parties' rights are determined. If the contract is rejected, now you've got to remember the servicing entity is going away. Okay, it's filed Chapter 7. It's no longer going to operate.
Mm-hmm.
Okay, a Chapter 7 is a liquidation. And so what you now have is a contract that's been breached or rejected by the bankruptcy trustee, which now only has two parties left to it. Okay, it has the annuitant and the issuer. Okay, I'm talking about the servicing arrangement.
Yes.
Okay, I'm not talking about the order allowing the purchase of portion of the annuity payment stream. The annuitant would have the right to go to the annuity issuer and say, I now want you to pay me directly, okay? Because that contract doesn't exist anymore.
Mm-hmm.
The contract's been rejected, okay? And so now there is no servicing contract. The annuitant should have the right to essentially request payment directly from the annuity company. Now the trustee may have an issue with that, okay, because the trustee has a piece of that payment stream still.
Yes.
That's an asset of the bankruptcy estate, and that is valuable. And so the trustee may ask the bankruptcy court to, ask the bankruptcy judge, let's allow those payments to come into the bankruptcy estate and be held. That is the entire payment, okay, and or allow the annuity issuer to hold the entire payment, and let's determine, okay, what we're going to do with this contract, and let's make sure my rights to the portion of the payment stream aren't affected. And that may end up resulting in a negotiation between the three parties, the bankruptcy estate, the annuitant and the annuity issuer, in order to find an arrangement that's accommodating to all three.
Bruce, yeah, thank you very, very much. I think you've done a great job at explaining what Chapter 7 is, and also given us a few things to think about, as well as the people, my listeners and my readers, given a few things to think about. And we really appreciate your time on taking time out of your busy day to give us your opinion.
No problem, John. Thank you so much for the opportunity.
So what conclusions can we draw from what we've heard today so far? If you're a life company and you are refusing to split payments, having heard what Mr. Akerly said, do you really feel that this is something that you want to do to your customers? Okay? Do you want to expose your client to a potential Chapter 7 bankruptcy if it ever happens? Again, as I said before, if you are a 150-year-old company, That's what I'm a settlement planner, that's what I'm selling. I'm not selling some third party's services down the road that I don't even know about. So think very carefully about what your business practices are, because we care about your being in business and you're providing long-term financial security. These are very important things to think about. If you're an attorney, you need to be asking these questions as well. We know that many of you are concerned about your clients selling their future periodic payments to their structured settlements. Should be one of the questions you ask is, what about structured settlement servicing? If you are a settlement planner or structured settlement broker, please listen to this interview. Understand what the issue is. This is no small issue. As Mr. Akerly said, if down the road there is a Chapter 7, however remote that is, this servicing agreement becomes part of the bankruptcy estate. It's a situation that may involve costs to your client down the road, long after you've done your planning, or perhaps if something happens, it could be shortly after you do your planning. But the fact remains, there may be additional costs, additional emotional overlay, and other bad things for your client and possibly your reputation because you didn't do your homework on this particular issue. I'm John Derer, and thanks for watching on the Legal Broadcast Network.